You got 3:30. Do you have 3:30?
I have 3:30. My name is Andrew Wolf. I'm the vice chairperson of the City of Sugar Land Independent Ethics Review Board. I am convening this meeting on Monday, January 8th, 2024 at 3:30 p.m. We'll now call roll. Please respond and advise whether you're attending in person or remotely. Krista Stegmiller. No response. Ann Malek.
Here, in person.
Chris Crosby.
Present in person.
Rachel Varghese.
Here in person.
Raquel Roberts. Steve Trulli.
Present in person.
Doug Earl.
Here in person.
Larry LeBeau.
Present in person.
And I, Andrew Wolf, Vice Chair, am present in person. Additionally, Timothy Kerwin of the Kerwin Law Firm is here today to assist us if we have legal questions regarding today's meeting. Do we have anyone, Ms. Robin, do we have anyone signed up for public comment?
No, no one has signed up for public comment.
Okay, well, then we're going to go on. The purpose of this special meeting is to review a sworn complaint filed with the city secretary on December 19th.
Hold on one second. We have on the agenda an item on the minutes. So we'll need to, what's next, the minutes, correct? You want to have them take the minutes now? And then we'll do the complaint next.
Okay,
If you go to the second page. That's right. Consideration.
okay. Oh, I'll do that agenda. Okay. Next on the agenda is consideration of action on the minutes of our December 4th, 2023 meeting. Has everybody read the minutes, been provided them? Does anyone have any questions or changes? Can I get a motion that we accept the minutes as is with no changes?
By motion.
I second.
Vote?
Aye.
Aye. Any abstention? Motion passes. Now. The purpose of this special meeting is to review a sworn complaint filed with the city secretary on December 19th, 2023, alleging a violation of the Code of Ethical Conduct by Mayor Joe Zimmerman in accordance with Section 2-99 of the Code of Ethical Conduct. Our review today is limited to determining if sufficient cause exists to proceed with an investigation or if the complaint should be dismissed. We are not here to discuss the merits of the complaint and will not be receiving any testimony related to the complaint. Our review will be limited to the complaint and the city attorney's report regarding compliance with the requirements of Section 2-98B2. After reviewing and discussing the complaint and the report, we'll vote to decide whether the complaint should, these are our three options, be dismissed as frivolous or dismissed because the subject conduct was undertaken in good faith reliance on a formal written opinion of the city attorney, or it should be investigated. Can we keep going, or do we start discussing it?
You can start discussing this.
Okay. Have all of you had an opportunity to read the complaints
Yes.
and all the associated documentation with it this time?
Yes.
Okay. What I think we should do, what I'd like to do is everybody go to page 54 of the packet, which states clearly for us what the allegations are. And we can take them one by one. Everybody have that up? All right. So allegation number one, Planning and Zoning Commission training requested by the mayor. The allegation is that the mayor said he requested it and that the complainant could not find that request in writing. If you had a chance to look through the open records request.
Page 10 of 55. Page 10 of 55 reflects the mayor's statement on 4/25 of 2023, alleged violation number one of the complaint.
So the mayor states that he contacted Lisa Koshich Meyer, who's our planning, long-range planning. And the city said that they did not have documentation in writing that he requested that. He might not have requested it in writing. He could have done it verbally, in which case the city would not have documentation. So just because it's alleged that it occurred and he doesn't have documentation that he did it, she doesn't have documentation, doesn't mean that that request wasn't made.
Or the other thing I thought of, there is annual training, right? Like there's some kind of annual training. And so because I remember this and I think you couldn't say, well, when that annual training comes up, we could do it then, you know? I mean, there's different ways I think it could be interpreted.
Yeah.
There's nothing.
Yep.
And from what I could tell, there wasn't anything that said it had to be written. Did I get that incorrectly?
No. So you are correct in that it doesn't say that
It
he had
doesn't
to request it in writing.
And I want to just make a sort of since this is the first of 5 allegations we're going to sort of have to go through, we can't discuss what I call the merits of these claims. However, I think you have some threshold questions that y'all are asking that are not necessarily delving into the merits of them. They're more threshold questions. For example, she has made the allegation, and then her allegation, if you look at that, is the city has no responsive records, but she's not providing anything that the city didn't provide. Like, I have the record, the city failed to provide it or something like that. So we have to just be a little cautious on how we proceed through these 5. And I think you're all within the field right now. But we'll just be real careful, and I'll try to help y'all as much as I can stick within the boundaries of kind of maybe the threshold questions that aren't dealing with the merits. Thank you.
And if it's if it's a he said, she said situation, and there's no requirement that it's in writing, then does it hold merit to continue?
That would really be this board's call, whether or not you want to move forward with an investigation or dismiss that as frivolous.
We discussed doing was going through each of these and then taking a motion vote as to whether or not we believe this particular allegation should move forward. And then at the end, we tally everything up and we'll have our answer.
Well, can I ask one more, I guess, a legal question? In a case like this, the original complaint was about social media and somebody's reputation. A lot of these violations that she's bringing upon doesn't relate to that. It relates more to the nuts and bolts, the workings of the Planning and Zoning Commission. Would all these violations be applicable?
And again, I'll have to defer to the board, what you find to be what I would call relevant. And so the underlying initial hearing was on one subject. Yes, this was discussed at that initial hearing, correct? but might be sort of outside what that particular topic was. Is that, does that sound correct to you, sir? Right? And so, well, let's say, I'm gonna give you kind of an outrageous example. Let's say the mayor stood up at that meeting that was about one thing and said, you know, the earth is flat. Okay, that wasn't what that was about, whether or not the earth is flat or not, right? But I'm going to leave that to this board's purview on whether you feel it's relevant to move forward based on if it was an ancillary statement that was made at that meeting as being relevant or illegal.
So one other comment, and as I poured through some of the government codes, I'm not sure if anybody's familiar with, excuse me for a second. The Title V, Open Government Ethics, are you familiar with that, or is that applicable, I guess, to this hearing? It's Open Government, Chapter 551, Open Meetings.
Yes, that would be, you are subject to that, correct?
All right.
Yes, at this meeting.
So there's a subset, and I'm not sure if I'm reading this correct or incorrectly, or if I'm interpreting it wrong, but there's a section 551.042 that states if at a meeting of a governmental body, a member of the public or of the governmental body inquires about a subject for which notice has not been given as required by this subchapter, the notice provisions, and that's where I'm stuck on the notice provisions of this subchapter do not apply. And it goes on to say just a little bit more, a statement of specific factual information given in response to this inquiry. That meeting, you were not present at that hearing tended to go off the rail numerous times into what seemed like a planning and zoning meeting. A lot of comments about the development. And that's what we were not there for. So would that apply to the situation?
So what that section means is, you allow public comment during this type of meeting or the city council meeting or the planning and zoning commission meeting, okay? Now, if someone gets up and they are, talking about something that is not on the agenda, this board would only be allowed to do three things. They can make a specific factual recitation in response to what someone said. So if someone showed up today and was going to speak, okay, we had no speakers, but if someone got up and spoke and they said something that's not on the agenda, then the chairman typically could respond and say, oh, factually, this is how the city of Sugar Land handles X, Y, and Z. They can make a statement on an existing policy. The city of Sugar Land has a policy that addresses what you're talking about in its policy, blah, 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 right? X, Y, and Z. Or they can debate, this board can debate to put it on another agenda item. So I think you're mixing the bags a little bit here because the last meeting was, or the meeting that this complaint is referring to, I believe was a public hearing. And so when you're in a public hearing, it's different than public comments. A public hearing, you can ask questions to the person who is up there. They can respond. You can have like more of a dialogue, where in public comments, it is very limited. Does that make sense to you?
I think one of the things I wanted to say about this number one violation is that we're going back and looking, did the mayor lie under oath? That's the accusation, correct? And in this case, we're talking about, he said more training needs to be done. And so how can you lie about saying that? And then later, if the follow-up doesn't happen, that's still not lying under oath, is how I'm viewing it. And so in this case, I don't think this is a violation of the particular section that is being filed against.
And I agree. That's kind of what I was saying, is thinking of is, well, the things that have been said is, first of all, we don't know, maybe there was a oral conversation, something that's not written. And also not to say that it's still not being planned, because I do think there's annual training, so maybe it's on the agenda, whenever that annual training, we don't know. But I agree, like that lying under oath, what was said, I don't feel like it was lying under oath.
Any other comments on that, or can I get a motion on this first violation to either accept it and investigate it or dismiss it as frivolous?
And I think we maybe just make a threshold also statement that
Okay.
the city attorney did provide a report, but I don't believe that any of these 5 allegations were part of that report. And so that knocks out the number 2 option, thank you, that you have on your list. I just want to, so yes, you do have, Chairman, you stated it correctly. You
Okay.
basically have 2 options, dismiss as frivolous, or to move forward with an investigation.
I move we dismiss as frivolous,
Violation 1.
violation 1.
I'm the same, the Mrs. As frivolous.
Okay,
Agreed, frivolous.
we take a
So we have
So
a
we have
motion, is that your motion?
Stevie second, is that your second?
Oh,
Okay,
Okay, can we take a vote? All those in favor say aye.
aye.
Aye. Passed unanimously.
Okay.
Correct.
you want to call for any opposed? Just-
Okay, any opposed? All right. Then we'll move on to violation 2. The mayor's statement that planning and zoning commissioners can't take into consideration public comment. I looked on page 21 of our documentation, and I did not see anywhere where it says anything about accepting or not accepting public comment. I see that it has to follow state laws and it has to follow city ordinances. And make recommendations, but I don't see anything including or precluding following what public opinion has.
And again, if you have a threshold question that the relevance of those comments, and I would say that probably applies to 3 and 4. If it's this board's determination that the relevance, that those comments weren't really relevant to the underlying meeting that they were set at, you could make that determination as well. But I'll leave that to the board if that's.
Okay, so you say with group 2, 3, and
If you
4.
want to group 2, 3, and 4, they're. That's up to, I mean, we can take them we'll take them one at a time, but just.
Now, we don't have. We're not on planning and zoning, so we don't know what all of their policies are. But if we're going by the evidence given to us, as far as violation 2, again, I don't see anything that the mayor violated. In his statement. Does anybody see it? What he did, or any portion of that page 21 that could be conceived as
Looking at what they say right here is that the P and Z members had every right to hear the public opinion, but what the mayor said is take into account, not to hear. So I feel like he never said that you can't hear it, but it's that saying they're not to take into account. And so again, there's a lot of interpretation there, but the violation is saying that of course they have every right to hear it, but he never said we're not going to listen. I mean, I didn't see that written that. So you can hear the public comment, but taking into account is, something else that board does,
okay. So they make a public statement. P and Z listens to it. And they can totally ignore it. Okay.
That's what they're saying, yes, PNCs have every right to hear. I don't see the mayor saying we're not going to listen to.
Right,
I know it's words, but it's words.
right. But if she's quoting him, then we go by. Right, we go by what she said, he said.
I would also argue that on the purpose on, I guess it's page 21 of the packet, where I believe at one point, Ms. Miller had highlighted this section, and it says to protect the general welfare and interest of the people concerning physical changes. I believe you can protect it without necessarily going back to your point, taking public comment into account is different than looking out for the interest of the public. And so I think there's a differentiation there. And so I don't believe that those two are the same thing.
I don't want to go too far off into the weeds of like the merits of his statement. It's more just like as a threshold question. This is the statement she's complaining about, and then she's provided what she feels is contradictory authority, which again, I think as a threshold does, I think you can make as this board, what she is presenting, does that even meet the threshold? Less going into sort of like maybe the intent or who's, just does what she shows you in front of you, does that really even meet a threshold that y'all would want to move forward or not based on what you have in front of you?
And before we make that decision, are you comfortable taking 2, 3, and 4 as one motion? Or do you feel that they need to be split up? Pardon? The board. Since it all kind of pertains to the same thing,
Yeah, I'm comfortable taking one motion.
one motion combining 2, 3, and 4.
Correct.
Yes, correct.
Okay. Since we still are left with 2 decisions, since there was no city attorney opinion on this, can I get a motion that we either dismiss it as frivolous or accept it and investigate?
I'll make a motion to dismiss as frivolous.
For 2, 3, and 4?
I'm sorry, 2 and 3 and 4, dismiss as
Okay.
frivolous.
Second, Larry the Boot.
Do y'all need any more do you need any more discussion on maybe 3 and 4 before y'all vote on those? We did talk about 2. I mean, it might be the same threshold that if what she's alleging and you don't even have in front of you enough to make a determination to even move forward, then that's fine. I just want to make sure you have an opportunity.
Any other input, questions, comments? Okay, can we take a vote on the motion on items 2, 3, and 4 to dismiss it as frivolous? All those in favor say aye.
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 Aye. Any opposed? Motion passes unanimously. So we now go on to number 5. Allegations of mayor's comment regarding a council member's email opinion. And that is on page 25 of 55. Give you all a moment to read it. Anyone had a chance to read it?
What exactly is in a manner of speech? I keep coming back to that, thinking, does that
Tell me what you're referring to.
page 24.
Okay. This is page 24, just for the record, is reflecting the complaint where it says mayor's testimony
Mhm.
4/25/2020, alleged violation number 5. Mayor Zimmerman testified in a manner of speech that implied one of the council members found Commissioner Patel's video greatly concerning, stating the council member said, quote, "This, I think, crosses the line." I don't know. I would not be able to speak to what the complainant's intent is by testified in a manner of speech. It was a physically spoken speech. That's all I can say.
As a board, I think our responsibility is to say, did somebody do something wrong here or not?
Right.
Not implication, not maybe, maybe not, but do you have solid something to say yes or no? And that's how I'm reading this.
Great.
And her statement is implied, uses the word implied. So again, not getting into the merits, but
No.
do you have enough to go forward as a threshold if her allegation uses the word implied as opposed to,
Right.
something different?
The question, is this a conflict of interest with her position on P and Z implies that she may be crossing the line? That's all I'm reading.
But that's the merit.
Yeah, no,
Nothing in the
Right.
merit.
But the council member's question suggests that it was a concern, or they wouldn't have asked it. And without that councilman here to explain it, I said we take it at face value. And I think the mayor correctly voiced the concern of a city council member.
And I
Doesn't-
think it still goes back to the fact, did he lie under oath? That's what we're trying to get to today. And how can you lie when all you're doing is stating that something happened? And so an implication is not the same thing as an actual violation. And so I don't think it meets the threshold that we were looking for today to move forward with an investigation.
Actually,
So could I make a motion that we dismiss violation number 5 as frivolous?
Yes,
Rachel's
I'm
second.
sickening it.
Okay, we have a motion and a second. Can we take a vote? All those in favor of dismissing charge number 5 as frivolous, say aye.
Aye.
Aye. Any opposed? Nope, record show
You're an aye.
Okay.
You're an aye. Okay, no, you're not an opposed.
unanimous.
Okay.
I thought we were gonna have some discussion, but
Oh,
sorry.
Well, we've already voted, so we're.
okay.
Okay.
So we've gone charge by charge, or allegation by allegation. Every one of them has come back as being voted upon as frivolous. Do we need to take another vote?
Nope. I think we're good. I think we'll just
Okay.
move to adjourn the meeting.
Before we adjourn the meeting, I would like to make a request of the city secretary's office. Our time does not cost the city anything. All of these allegations do cost the city, and in fact, in the budget, on the agenda, there's a budget. Could you, okay,
We'll get with you.
we'll get with you afterwards.
Okay.
I did want to record that.
Okay.
Okay,
This is not, there's nothing on the agenda for it.
Oh,
I
okay.
don't want to get anybody in trouble.
all right. Well, in that case, we've done all the business for today. If there's no other questions, comments, input, suggestions, advice,
Motion to adjourn.
I will make a motion that we adjourn this meeting at 3:58.
I second.
All those in favor?
Aye.
Aye.
Anyone else? You can stay.
Excellent.
All right, meeting adjourned. Thank you so much. Excellent job.
Thank you.